Okay, good afternoon, everybody. My name is Brandon Hammer. I work at INCOR and the Transitional Justice Institute at Ulster University. I'd just like to welcome all of you to the seminar. I'll be moderating today and chairing, but in the background we also have Kate Turner from Healing Through Remembering, who's also moderating, just helping us with the technology, and also Rory O'Connell from the Transitional Justice Institute as well. So it's a great pleasure to have all of you here with us as part of our Dealing with the Past in Northern Ireland seminar series. It's an effort from the Transitional Justice Institute, from INCOR, and in partnership with Healing Through Remembering, and also myself. I hold a position called the John Hume and Thomas P. O'Neill Chair in Peace at Ulster University. And part of what we wanted to do in this seminar series was to really focus on the discussions around dealing with the past in the context of the conflict and about Northern Ireland. Our aim was really to try and widen the debate. I think many on this call would be familiar with the Stormont House Agreement and some of the current debates going on, but we wanted to also look at these issues from maybe a slightly wider perspective. We had originally planned, as some of you who've been on some of the seminars before, some 10 face-to-face seminars, and with the COVID situation, we've obviously changed that. Having said that, we've had a fantastic response to the seminars. Today, we've got about 50 people online. Last seminar, we had some 250 people online. So you're all really, really welcome, and I hope you'll find the seminar today interesting. And I just want to specifically thank Healing Through Remembering, who are our key partner on this initiative, which is important to us as we try and reach out to as wide an audience as possible. The seminar today is going to be given by Dr. Thomas Hansen, who is a lecturer in law at the Transitional Justice Institute in Ulster University. The paper is entitled, "Is the UK Heading Towards Combat Impunity?" Thomas asked me to mention this before he starts speaking, that his work is specifically focused on a much wider range of issues around accountability and impunity questions in the UK. So his work started in Iraq. So he doesn't see himself as a direct expert on the Northern Ireland context. And what we're hoping is that we'll be able to use this as a springboard and application to maybe the Northern Ireland context. So Thomas just wanted me to mention that, as he felt he might not want to speak about the specific details of Northern Ireland, but certainly can talk about the wider context and some of his research on accountability. So that's really all I need to say by way of introduction. I'm now going to hand over to Thomas, who will speak for about 30 or 40 minutes, and then we will have time for a question and answer session.
And thanks to you and Katie for inviting me to take part in the seminar series. I really look forward to talking about my research about combat impunity in the UK. And as Brandon says in the introduction, then my research sort of originates in wider questions around accountability in the UK for crimes by the military specifically, more than it connects specifically to Northern Ireland. But of course I'll be interested in hearing comments and questions about that topic, so probably I can learn something from today also. Well, so thanks everyone for joining in. I don't really know who exactly is out there and who's listening in, but I guess I will meet some of you later on and when we move to the discussion. So I think we got about an hour and a half for this, so now it's already a bit past 3, but as Brandon said, I will try to stick to around 30, maybe 35 minutes in the presentation itself, so we have enough time for interesting discussion after that also. So the presentation, it looks at various legal measures that are being proposed in the UK that aim to limit accountability in different ways for violations committed by soldiers in military campaigns abroad and in Northern Ireland. So as I mentioned, this presentation sort of takes the broad perspective that it looks at measures that are being introduced nationally in the UK, not specifically at what's going on in the UK, though, as I will return to later on in the presentation, there's quite the overlap here, that a lot of what is being considered UK-wide will likely also be introduced in a similar fashion in the North Irish context. So we'll get back to that later. My interest in these questions, it really started off with a research project funded by the British Academy that looked at accountability for war crimes in Iraq by UK soldiers. So that project sort of took an international law perspective, looking at this from what we call a complementarity perspective. So whether what was being done in the UK, if that was sufficient under the ICC statute to not permit the ICC to step in. So in that sense, I looked at those accountability measures both from an international and a national perspective, but mainly within an international legal framework. Following that project, I've done a bunch of follow-up projects, some of them with Carla Firstman from Essex, where we looked more specifically at the UK's military justice system, and later on also specifically at the different proposals that I will discuss in this presentation relating to statutes of limitation and derogation from the European Convention and other measures. So Carla and we submitted evidence to the Commons Defence Committee on this topic some years ago, and last year we also took part in the MOD's consultation process on these topics. So we've been, involved in it also very much from a policy perspective, if you will. So a bit of context before I go into this. So what is really going on is that the UK has for quite some time been considering a bunch of proposals that in different ways seem to aim at ending, undermining, or limiting accountability for British soldiers who have served abroad and in Northern Ireland. So this is quite a long process, but and we have a number of different proposals on the table, including a statute of limitation, a statute of limitations-like legislation. We have reform of the UK's own Human Rights Act. We have, well, connected to that, derogation from the European Convention, and we have what is being referred to as a civil litigation long stop and other measures that I will discuss in this presentation. I should say also at the outset that these proposals, these suggestions, they originate in concerns about criminal investigations and civil litigation brought in the context of the war in Iraq. So a lot of this really goes back to concerns among decision makers in the UK that a lot of litigation was arising out of the Iraq war and criminal investigations of soldiers involved in that campaign. So that is where it sort of started, but of course it also goes to an even longer debate about accountability for crimes in Northern Ireland. And I think in my view it's important that we look at what is currently going on, that we look at government's action and inaction more broadly relating to issues of accountability for the military. So just 3 points to briefly mention at this point, and I will get back to it in more detail later on. But one point is that we have seen quite ineffective, some would say dysfunctional by design, domestic mechanisms to investigate crimes committed in conflict zones. So notably IHAD, so the Iraq Historic Allegation Team that was set up to investigate crimes committed by soldiers in Iraq, has proven rather unsuccessful, really. So we had a mechanism with hundreds of investigators that has been working for several years under a fairly large budget, but nothing has come out of that. So the SPA director, Andrew Cayley, the Service Prosecution Authority, announced just the other day that most likely we will not see any prosecutions whatsoever emerging out of that process, and it has seemed like that for quite a long time. So that is quite puzzling when you think about it, that you had several thousand cases being investigated relating in one way or another to crimes in Iraq, typically relating to ill treatment of detainees or unlawful killings, and not a single of those cases will assumedly lead to prosecution. So that is something to think about. Secondly, we've seen what I would frame as opposition, possibly even a level of hostility towards the ICC process. So the ICC, the International Criminal Court, currently has what is known as a preliminary examination of the situation in Iraq. So that specifically focuses on the conduct of UK soldiers. So that examination of the situation in Iraq is limited to asserting whether UK soldiers committed crimes under the ICC statute, so war crimes during the Iraq war and occupation. And as you can imagine, UK authorities are anything but enthusiastic about being scrutinized in this way by an international court, and something that could, potentially, theoretically at least, lead to accountability for high-ranking military officers or decision makers in the UK. So the UK has taken a number of measures to try to, at least make it very clear to the ICC that they do not think this is a good idea. So they've been pushing for quite a while in different ways to see that examination terminated. And if you listen to what Andrew Kelly just said when he came out the other day, he sort of said that he expects that the ICC will not be pursuing this any further, and we're yet to see a decision by the ICC that this examination has been going on now for quite a number of years, and it has been last year the office of the prosecutor said that it would likely very soon make a final decision whether to proceed to a full investigation, but we're still waiting for that decision, even if it is now June 2020. So but let's see what will come out of that. And then thirdly, attacks the legal profession and human rights advocates. So this is something where we'll give you a few more examples later on in the presentation what exactly is. But just to say for now that certain authorities have taken a quite harsh stand against the lawyers and the human rights advocates that have been pushing for accountability, and legal proceedings have been brought against certain law firms, and sort of arguably a broader campaign against these folks that's quite troubling, really, from a rule of law and human rights perspective. So before I go more into the details with the different proposals that are actually on the table right now, I just want to briefly outline the process, and I won't bore you with all the details of this, but sort of essentially this goes back to 2014 when the Common Defence Committee conducted a major inquiry into UK Armed Forces personnel and the legal framework for future operations, concluding that the Armed Forces and the Ministry of Defence faced an unprecedented number of legal cases, a rise driven by the number and nature of the conflicts that the UK forces had been engaged in during that period, growing use of challenges under human rights law in UK courts. And that's important to note, that last quotation, because that is sort of what has, been emerging out of this over the last couple of years, that there is a huge annoyance among within the Ministry of Defence and more broadly in what you could maybe call the pro-military establishment, that human rights law applies to armed conflicts where the UK takes place, has brought with it a lot of litigation. So that's one key area of concern among many decisions makers in London, that human rights law really permits for this kind of litigation before UK courts and before the European courts. So that's an important point. Then in 2017, the Defense Committee published another report called Who Guards the Guardians, which concluded that I had. So the Iraq Historic Allegation team that I spoke to before was unfit for purpose, has proven deaf to the concerns of the armed forces, blind to their needs. Record closed, which then very soon afterwards, I think a few months after the Defense Committee had recommended its closure, the Ministry of Defense announced that it would be closed down and replaced by a smaller but really quite similar body. And it also demanded that the government enacts a statute of limitations. Moving on then to June 2018, the Defense Committee launched a new inquiry into the question of how former service personnel can be protected from the spectra of investigation and reinvestigation. And in May 2019, the Defense Secretary at the point announced that the government would make a series of proposals to provide for what she called stronger legal protection against prosecution for current and former service personnel, including what was then referred to as a presumption against prosecution for battlefield-related crimes. And I will speak more in just a few minutes about what that presumption against prosecution really is. And then most recently, in March this year, the government introduced what is called the Overseas Operations Bill. It's gone through its first reading in Parliament now, but the second is still pending. And just to say that, I think had it not been for everything else that has been going on, the introduction of this bill would probably have received somewhat more attention, but it has received surprisingly little attention among commentators and the media and others. So hopefully some more attention could come out of this presentation, perhaps. Anyways, turning to the proposal. So we have first what I call a statute of limitations like proposal. So that has been formulated either as a qualified statute of limitation, which was supported by the Defense Committee, or a presumption against prosecution, which was supported by the Ministry of Defense. And the March 2020 bill moves towards the presumption against the prosecution. So it's not being referred to as a statute of limitations, but as we will hear about, in many ways it would probably have quite similar effects to a statute of limitations. So importantly, that assumption covers a 5-year period, basically meaning that any crime by the military committed overseas, or any suspected crime by the military committed overseas that happened more than 5 years ago, that the very clear starting point is that such a crime cannot be investigated by UK authorities, subject to a number of modifications. And it also does not cover Rome Statute crimes, which is quite notable, and in a sense it's positive. I don't think, well, looking at some of the earlier proposals, they did not exclude international crimes and Rome Statute crimes from the presumption, so that's a positive development that they're not included. I'm not sure how significant that really will be in practical terms, because quite often you would see some of these crimes being prosecuted, or well, investigated and prosecuted with reference to UK law more than with reference to international law. So the practical difference might not necessarily be that significant, depending, of course, on how investigators will pursue this in the future. So I think that's quite deliberate that they excluded Rome Statute crimes. There's been, commentators had noted on earlier proposals that if they did include that, I think very likely the ICC would have reacted to that in one way or the other if that was in effect covered by a statute of limitations. So quite deliberate. I'm sure that it wasn't included, and of course also with reference to the ongoing examination of the situation in Iraq, where UK authorities are still not aware what will be the outcome of that. Secondly, we have seen a proposal to derogate from the European Convention on Human Rights, and really this has been quite a long debate in the UK, that that various governments over the last many years have in different ways talked about the need to get out of the European Convention, or at least to derogate from it in times of armed conflict. And sort of what the Defense Committee hinted at is that they would like to see a standard derogation for any armed conflict that the UK was a party to, but I think most commentators agree such a standard derogation wouldn't really be permissible under the European Convention. So probably that's why the March 2020 bill instead says that there's a requirement for the Secretary of State to consider on a concrete basis whether it's appropriate to derogate from certain rights in the convention. So of course that's positive, that it's not a blanket derogation, that it does need a case-by-case analysis as is required on the convention itself. And also this seems to be in many ways, I think, quite symbolic, because if you do look at the kind of claims that have come out of the conflicts that the UK have been a party to, then most of those, they relate to rights that you cannot derogate from, that you cannot make exceptions to in any ones, namely torture and other forms of ill treatment and unlawful killings. So the practical effect of any derogation might not necessarily be that significant. So just to mention that. Third, we see a proposal to amend the US Human Rights Act. And again, that has seen various formulations over time. What the March 2020 bill does is that it will amend the Human Rights Act by introducing an absolute 6-year limitation long stop for claims under the Human Rights Act with respect to overseas military operations, and it will severely restrict the court's ability to extend time limits, which is quite disappointing and quite a serious question, really, if you look at it from the perspective of victims, because had this been in place, then it would have meant that many of the claims arising out of the war in Iraq and other conflicts, but mainly Iraq, would not have been it would not have been possible to bring them before UK courts. And if this bill is passed, then it will no longer be possible in effect. Closely related to that, there's what is called a civil litigation long stop, so whereby legislation should be introduced to restrict UK courts' discretion to extend the normal time limits for bringing compensation claims for personal injury or death for events occurring outside the UK. And again, the March 2020 bill introduces an absolute 6-year limitation for such claims. So again, this seems pretty far-reaching, really, from the perspective of access to justice of victims in these conflict zones. Lastly, it has been proposed that a new partial defense should be adopted, whereby service personnel would see convictions for murder reduced to manslaughter in certain circumstances. Well, those circumstances, according to the proposal made by the Defense Committee, were really quite far-reaching. Fortunately, the March 2020 bill did not include any provision for such a defense, which would have been very problematic, I think, from a rule of law perspective. Very briefly, how do these proposals then apply to Northern Ireland? Well, first of all, it's clear that the bill as such does not apply to Northern Ireland, because it applies to operations of the armed forces outside the British Islands. So that being said, the Secretary of State for Northern Ireland, on the same day that the bill was introduced in Parliament, gave a written statement where he said that they would aim to ensure equal treatment of Northern Ireland veterans and those who served overseas. So if you check that statement, it's saying that the ambition, the objective is to make sure that everything that's covered in this bill would also apply in the same manner to Northern Ireland. So that was sort of an overview of what's going on, what's on the table, what does the bill say, and how far are we in this process. Now I'll try to dig a bit into how to understand these measures. So I think maybe a useful way of framing it is to ask, is this a question of lawfare, or is this a question of war on law? So the former Secretary of State for Defense, she labeled this in one of the reports by the Ministry of Defense lawfare. So basically saying all this human rights litigation coming out of Iraq and other conflicts where the UK has been involved is really sort of a question of left-wing human rights lawyers making money out of this. It's very frustrating because there are no merits in these claims, and it really stresses the service personnel to have this the threat of litigation, and of course the Ministry of Defense itself is also very annoyed that they have paid out of millions of pounds in compensation, because a lot of these claims have been settled, so out of court settlements where we don't know exactly what is, what has been accepted by the ministry, but we do know that they have been paying out a lot of money. So that goes with the sort of narrative I spoke about at the outset. This is really a question of, there are no merits in these claims, so if anything, it was a few rotten apples in Iraq who committed, a crime here and here, but there was nothing systematic. There were these crimes did not happen on any large scale of widespread fashion. That the UK had policies in place to ensure that detainees were interrogated in manners that comply with the relevant conventions and so forth. So a huge annoyance really with the lawyers and the human rights advocates, and even with the courts that have been involved with this, so including UK courts and including the European Court, and that's been sort of the rationale for decision makers in London to move ahead with this. So yes, we have seen quite a significant amount of civil litigation, and as I just mentioned, a lot of that has really led to settlements where the Ministry of Defense has decided to compensate victims, and how the ministry approaches that is that it basically says, we cannot resist these speculative compensation claims, so we kind of forced to pay out when they're being brought, and that does sound a bit puzzling to me. And I included here a quote by Nicholas Mercer, who used to serve as the legal advisor to the UK Armed Forces and the UK Army during the Iraq War. And he says, anyone who has fought the MOD knows that they don't pay out for nothing. Clearly, this isn't just one or two bad apples, as they have been characterized. This is on a fairly large and substantial scale. So that's an important argument, I think. Also true that we've seen some criminal investigations. A lot of the annoyance in the pro-military establishment has been framed sort of as this is a question of re-investigations, so investigations being opened and then later on, then closed and then later on reopened. And if you look at the facts, that's really not true. That only a fairly small number of these investigations are what you could reasonably call re-investigations. So most of them are actually new investigations. And even where you have re-investigations, of course, you can ask, what is the question why UK investigators decide that an investigation needs to be reopened? Well, it's got to do with the fact that the initial investigation did not comply with the legal requirements as has been established by UK courts and the European courts. So, of course, a better solution would be to do a proper investigation in the first place. Then you would not have to do a re-investigation. Moving back to what I introduced to begin with, concerning attacks on the legal profession and the related processes. So I included here a number of quotations by, first you see former Prime Minister Theresa May saying, "We will never again in any future conflict let those activist left-wing human rights lawyers arrange and harass the bravest of the brave, the men and women of our armed forces." So that statement was made after, in the context of civil litigation and criminal investigations relating to the Iraq War a few years ago. And former Prime Minister David Cameron also promised to crack down on spurious legal claims and stated that, "I want our troops to know that when they get home from action overseas, this government will protect them from wounded by lawyers over claims that are totally without foundation." So he's assuming a lot here, of course, that all of these claims are totally without foundation, and many other statements have made. You see another one here by Bob Stewart, who was on the Defense Committee at the point, but it's really been, sort of a broader campaign by decision makers and aspects of the pro-military establishment, if you will, that has gone out very hard against the lawyers and the legal processes involved with this, and a lot of that seems quite troubling from a human rights rule of law perspective, in that you're assuming what should be the outcome of open investigations. You're criticizing very heavily the lawyers involved in this, and I've spoken to several of the lawyers who have received death threats and been intimidated in many other ways, and I think it's fair to speculate that somehow at least connects to that broader narrative that has been devised by the pro-military establishment and by certain media outlets in the UK. I don't think it's necessary to name which ones, but surely certain media outlets have been very active supporting that voice. So maybe just briefly to round off the presentation, why is it important to have accountability for crimes by the military? And I tried last night to come up with a list. I don't think this is an exhaustive list. There are other reasons, of course, but some of the most important ones, in my view, is to, well, first ensure that the rule of law applies equally to all, and that no soldier is above the law. So ideally, you would want the same standards to apply, if not stricter standards, to soldiers who carry weapons and are allowed to use deadly force under certain circumstances as to ordinary citizens. Next, effective investigations and prosecutions, they ideally at least promote non-recurrence of crimes by soldiers. So that's that deterrence argument, a preventive argument. Investigations and prosecutions, they make clear that certain behavior will not be tolerated. So there's things you cannot do as a soldier, and credible accountability measures are quite important, really, I think, to help establish that norm. So it serves sort of an educational purpose, if you will, and very practically, I mean, one example could be the use of the 5 techniques, which many of you will know were deployed in Northern Ireland, and the British government accepted that and said that it would not do that again. But then came Iraq, and 5 techniques were used again, and well, introduced softly, but quite clearly used, and also in other contexts. So that educational argument is really quite important, I think. Of course, timely investigations, they also bring about closure both to the victims and to the suspects. So, of course, I think the perspective of victims is very important, but it's also important for soldiers that investigations are efficient and timely, so those who are innocent can be cleared of any suspicion. So that's an argument that, in a sense, that the military itself ought to support. Importantly, of course, also with the international legal frameworks we have in place now, that if you do not have a functional and efficient domestic accountability system, then it increases the risk that you will see your citizens prosecuted by the ICC in The Hague. So that is what you could refer to as the complementarity argument. And then, sort of on a broader note, accountability is important in and of itself. Any country that wishes to be bound by the rule of law, so it's got to do with credibility. It's got to do with that country's image and standing abroad, and of course that also goes with the ability for a country such as the UK to be able to influence international processes and and legal frameworks, that you do need to have that international standing, of course, to do that. So to the extent that the EU heads towards combat impunity, it would be rather difficult, of course, for UK diplomats to go around the world and say that that other countries to adopt transitional justice measures and promote accountability for international crimes. So just to conclude, even if some of the most radical proposals are not included in the March 2020 bill, still some of them are quite far-reaching from a rule of law and human rights perspective, and I think there's a serious risk that they could go under the radar due to other current events. So important for us really to engage this topic, I think. I was asked when I did a similar presentation last week whether we should view this as something that, you know, goes to Brexit and sort of a nationalistic agenda, and what is this really about, or does it have to do with sort of a longer tradition perhaps in the UK that you do not promote accountability for the armed forces? And I think there's probably a bit of truth in both. I think certainly it's quite important to keep in mind that historically there's been very, very few instances where UK soldiers have been held accountable for crimes committed in the context of decolonization, Northern Ireland and elsewhere. So there's a broader one here where probably these current proposals they fit in quite neatly, though they do seem to depart in the sense that they are, well, they're not even trying to obscure that this is really about promoting combat impunity. So I think typically in the past it has been sort of less transparent, but this time it's quite clear that this is the objective, that we want to make sure that that British soldiers and British commanders are not being investigated or prosecuted for any alleged crimes, and we want to make sure that the Ministry of Defence is not being sued in civil suits. So just to round off with a quote by McAvoy, who said that this was said in the context of the statute of limitations proposal when it was framed in that version. But I think the argument, probably, I don't know if Kieran is on here today, but if he is, he can maybe tell us if he thinks that would apply to the presumption against persecution, that this would put the UK in the same league as former dictatorships in Argentina and Chile and Robert Mugabe's government in Zimbabwe for the UK to join. It's extraordinary, really. So thank you all.
Thanks very much, Thomas, for a really interesting presentation, and you supplied us with a lot of detail, a lot of food for thought, for sure. I obviously have some of my own thoughts, but maybe I'll hold those off and open up for questions. So as I explained to everyone before, the strategy that we'll take is, if you have a question, could you type it into the chat box? The chat box is open if there are any questions. Fatima had posted a couple of questions, which I think are slightly broader than what you're talking about, but until anyone else starts putting some questions in there, maybe I'll kick off with those. Her first question really concerned the Human Rights Act. She wanted to know if you had any predictions or updates in relation to that. Would ultimately there be some new form of Bill of Rights? Perhaps how does that relate to what it is that you were also speaking about?
Thanks for the question, and Brian for passing it on. I mean, it's quite interesting really to note that a lot of the frustration, a lot of the irritation among decision makers and among the military has been directed towards the European Convention and the European Court. But of course, I mean, your question sort of raises the spectre that the UK has in fact domesticated that convention through the Human Rights Act. So simply sort of leveling the frustration towards Europe and the outside world and international law is a bit misplaced, really, because this is also UK law. So if you are to do a lot of this, you not only create a problem from the perspective of international law, but you also bring into question issues of compliance with the UK's own legal framework. And to my knowledge, now I must admit that that I haven't found the time over the last couple of weeks to really closely scrutinize what's going on in terms of the process. But it's my understanding that that relevant parliamentary committees are yet to fully scrutinize, well, at least to fully comment on the bill. So it will be well. Hopefully, we'll see some comment from the Human Rights Committee on what's the perspective on different on these various proposals. And will we see? Well, the bill introduces a number of changes to the Human Rights Act. Will we see sort of a broader reform of the Human Rights Act? I'm not too sure really, because I think a lot of the annoyance here goes towards human rights application to UK soldiers, or more broadly UK citizens abroad. So at least in this context, what is really the annoyance is that human rights law applies to, well, increasingly applies to situations of armed conflict, and that's been sort of, the argument by many of those who have supported these different measures, that we have international humanitarian law that governs armed conflicts, so we don't need human rights law to also apply. And well, there's a long-standing debate about that. The fact now is that that certain parts of human rights law at least applies to certain aspects of armed conflict, and that's fairly settled by now by UK and international courts. So I don't think you're going to change that. I don't think we'll see ourselves in a situation where human rights law all of a sudden doesn't apply to international armed conflict before. It's an interesting question also, of course. So what's really the annoyance that human rights law applies to armed conflict when you have many of when you have many of the same prohibitions in international humanitarian law? So torture and other forms of ill treatment is prohibited under the Geneva Conventions and other instruments of humanitarian law, and also prohibited under human rights law. And sort of, I don't want to go into the legal technical details, but sort of overall, it's pretty much the same prohibition, and it covers the same conduct. So why really be so annoyed with human rights law and not with humanitarian law? And I think probably at least one very important aspect answering that is that human rights law gives victims the ability to litigate. So whereas that's much more difficult under international humanitarian law, requirements to investigate and prosecute are now very clear under human rights law, but the state's obligations are much less clear under international humanitarian law. So in other words, you're much more likely to see civil suits and investigations being brought with reference to human rights law as opposed to international humanitarian law. So I think that's that's probably one of the main concerns here.
What I had said is that Brian Doherty had posted a question, which I think is similar for many people, saying it's quite difficult to listen to this without thinking about the Northern Ireland context. And considering the 1998 early release scheme and the subsequent on-the-run letters, he asks, has an amnesty not effectively been in force in parts of the UK since 1998 anyway?
Yeah. Well, again, sort of the technical details of what has happened in the context of Northern Ireland. I think maybe you, Brandon, or you, Kate, would be better placed than me really to comment on that. But maybe, I mean, my sort of broader comment to that question would be that what is being introduced here does look like me a lot like a statute of limitations. So it's not called a statute of limitations. Its effect would seem to quite likely, I think, be the same in many ways. And the idea is, as I mentioned in the presentation, to include the similar measures for Northern Ireland. So that's yet to happen, but that is the stated intention, at least.
Okay. So Kiefer O'Hagan asks this question: Has the UK military taken any steps to reform or change its strategies or tactics in regard to military operations or detainment procedures to ensure future human rights or international human rights law violations do not occur? Specifically, if they wish to stop legal proceedings, have they taken action to ensure that soldiers are aware of their obligations under international humanitarian law and human rights law? So, yeah, I think it relates to your comments about the lawyers being seen as litigious rather than as trying to enforce something. And so she's asking about those changes. Have there been changes?
You need to maybe first look at what happened in a situation like Iraq. How was it possible that we seem to have witnessed abuse of detainees, at least on a fairly large and perhaps systemic scale? And the issue seems to be that, of course, the UK military walked into Iraq without necessarily being fully prepared. So if you speak to Nicholas Mercer, for example, who was the legal advisor to the UK Army at the point, he would say that this was a very difficult situation, that commanders didn't necessarily know what's going on, what's the expectations, how many prisoners of war are we likely to take. All of a sudden they found themselves with thousands of prisoners of war, and they hadn't been planning for that within the Ministry of Defense and within relevant units. So it was all sort of very ad hoc, is the perspective that I'm getting when it comes to this. And then you had the legal advisors like Mercer, who told the army that the Geneva Conventions apply here, and there's certain things you do to a person you detain, a person you interrogate. And if you ask Mercer, he will tell you that he went out and witnessed. I mean, he looked at these detention facilities and told the commanders that what's going on here, it doesn't look like it complies with the Geneva Conventions, really. And he would then say that he was told by the commanders that that's not really any of your business, Mercer. We're reporting, we're taking instructions from London, so don't come here and tell us how to treat detainees. So it's an issue I've been trying to understand, how where did this exactly come from. And it seems that the impression I'm getting, I don't have any sort of hardcore evidence to support this, but the impression I'm getting is that there was, at some point into this at least, there was sort of an approach was taken that we do need to go tough on these prisoners, and we're willing to use the 5 techniques and other techniques that are prohibited under international law. And of course there were no instructions to torture. You don't have a memo saying that interrogators should torture detainees, but that seems to have been widespread acceptance within the system that it was okay to go very tough on detainees, at least. So for me, I also look separately at ill treatment of detainees and the allegations relating to unlawful killings. So I don't think with respect to unlawful killings that you had, I mean, you've got to remember this is also a combat zone. So of course, I mean, soldiers shouldn't be too trigger happy, but it's also understandable to some level. I think that a soldier under a lot of stress being fired at, I mean, doesn't necessarily go through the Geneva Conventions before he shoots back, right? So I think you need to distinguish between treatment and unlawful killing here. And sort of going more directly to your question, some has been done since this. So the Ministry of Defense has set up what is known as a systemic working group that has been looking into additional training. So it seems international humanitarian law training is better now than it was at the point where we saw the Iraq war starting, and so some improvements in terms of training of soldiers. I'm not sure how much of a difference it would make, really, if we saw a new armed conflict now on the scale of say the Iraq war, but certainly the picture I'm getting is that there's been some improvements in that legal training.
There's a question here from someone called Claire Simmons. And it sort of links with what you're saying, and maybe it's just putting you a little bit on the spot in terms of the list you gave at the end. And she's saying, out of the reasons you mentioned, what do you think is the most effective way to convince the UK government to more effectively combat impunity in these contexts? Is it the threat of the ICC improving their image, first convincing the public and the military that international humanitarian law isn't the enemy? So I suppose she's sort of asking you, well, what do you think is the best way to do this? I know you've spoken about a range of strategies.
I certainly would think that the argument that this is really in the military's own interest ought to be quite compelling for the military and for pro-military people. That if you don't have accountability, the UK's military forces they lose their standing internationally. They will be less respected by other countries. Again, I'm not a military expert, but as far as I know, I mean, UK forces as such tend to stand quite highly regarded among other countries. But of course, if you create a pattern where they commit crimes that are not being, where the relevant people are not being held accountable, then that standing would surely suffer. So I think that ought to be a compelling argument to the military and for those who take that perspective. I also think that the argument of the ICC ought to be quite compelling, that the UK has committed. The UK was a strong defender of establishing the Rome Statute, of convincing other countries to ratify the Rome Statute. So it's really been a driving force behind establishing this accountability framework at the international level. So that's important to keep in mind, and it ought to be a strong argument in favor of doing this domestically, that being investigated and prosecuted, or seeing arrest warrants issued for UK soldiers or UK officials from the ICC. So that's a pretty important argument.
Claire Hackett has asked, do you think the lack of accountability in Northern Ireland over an extended conflict has had a consequence for Iraq and other modern conflicts that Britain are now involved in? So she's asking about that cross-border or cross-jurisdictional influence, whether in practice or law, I suppose. And maybe she's not asking necessarily about the law, but what do you think of that?
Yeah, right. I mean, I think that's a very interesting question. It deserves more attention than what I've been able to give it in my own research. But I mean, again, back to the 5 techniques. I think that's quite interesting that you saw them being deployed in Northern Ireland. You saw then UK authorities saying after that that was a bad thing. Or at least we won't do that again. And then you see those practices being introduced in other more recent conflicts, including Iraq. So that's quite interesting. And looking at it from an accountability perspective, of course, you can ask, well, might the situation have been different if those responsible for authorizing and implementing those techniques and well, other techniques that breach international law in Northern Ireland had been held to account. And perhaps I'm a little bit naive here, but I would like to think that the answer might have been different, that we wouldn't have seen this reintroduction in Iraq if that had actually been accountability for it in the context of Northern Ireland.
Because I had not taken Derek's question earlier, I might just, you don't necessarily have to comment on it, but he just posted a response to Claire's question, saying, in his opinion, Britain is not alone. All conflict situations from history could be discussed in the same way. America and Vietnam, the church all over the world, and many others. It's an unfortunate aspect of being part of the human race. So
interesting perspective, of course, and well, Derek, I mean, I would surely agree that the UK is not alone. The UK is not the only country that's facing some pretty significant challenges, if you will, with accountability for the military and perhaps more broadly law enforcement. And the US, of course, quite easily comes to mind, right? That being said, I mean, at least in a European context, I would say the UK right now does stand out. So as far as I'm aware, I don't have all the details, of course, but as far as I'm aware, you haven't seen anything coming close to this in other major powers, say France, that also tends to be quite active with this military. So so if you will, perhaps, I mean, the US, of course, has not been particularly prone to support that accountability actually happens for war crimes either. And just to reflect on that, we also have now an investigation relating to the situation in Afghanistan that involves U.S. armed forces and the CIA, and that's probably a good reason why we see the US and the UK being involved in these processes. That they tend to be very active in terms of using their military abroad, and they're both seemingly moving in a direction towards some level of combat impunity. That I mean, even under the Obama administration, it was made clear, of course, that nothing would be done by alleged crimes committed by the CIA. So there was a de facto amnesty, which again is I mean, equally problematic from an international law human rights perspective. So yes, the UK does not stand completely alone, but in a European context, it does stand quite alone, really.
Yeah, and I think that links to a question there again from Kiefer O'Hagan, and thanks you for answering the earlier question, but it links directly to what you're saying. So she said, I wanted to ask about how this combat impunity and possible statute of limitations is able to be defended and proposed by the UK, given the fact that both these aspects are prohibited under the Geneva Conventions and human rights law. Would the bill not effectively be useless at the ICC or other international bodies?
I think there's a very good reason why the UK is not calling it explicitly a statute of limitation, that instead they sort of invent this new term of a presumption against prosecution. So that probably goes very much to the heart of your question, that we know about statutes of limitations. There's a fair level of consensus that they're not permitted, at least when it comes to the core international crimes. So the UK would really, I mean, surely would have brought itself on coalition course with various international legal frameworks had it sort of adopted a blanket statute of limitations. So I think that's, you know, an important factor, understanding why it's doing something else, and also why, as I mentioned in the presentation, as the bill currently reads, at least, it does not cover Rome Statute crime. That's important, and in a sense, it's positive or less negative compared to some of the proposals that had been tabled earlier on, which did not speak about excluding international crimes. So a level of progress, but I think that level of progress goes very much to the fact that of course you do have good international lawyers being employed in the Ministry of Defense and other relevant departments who can tell the folks who introduced the bills that you can't just call it a statute of limitation, and you can't just include explicitly international crimes, because then you do get yourself into trouble. So again, the question is if the difference is going to be very big in reality with that different terminology, and personally I'm not so sure about that, because the intention remains the same. Quite simply.
Not sure if I completely follow this question, but maybe I'll just read it out and see what you make of it. It's from Terence Wright. If human rights legislation is used as a means of continuing conflict as war by other means, is it legitimate to set a time limit for the pursuit of claims?
All right, yeah. I mean, I'm also not sure if I completely understand the question, but the question seems to imply sort of that this lawfare argument made by the former defense secretary and others is sort of the right way to look at it. And I mean, my perspective at least would be quite different. That you seemingly have a fairly large number of violations happening in these conflict zones, and the only way for victims to sort of get access to justice is to rely on this framework for litigation protection and remedies that human rights law provides. So my personal take on it is that we're quite lucky to have this human rights law framework that gives us access to that, and but by extension also it would be rather problematic if the UK is going to severely limit those possibilities, as will happen if the bill is in its current form.
Yeah, there's a comment here from Martin Snodden, which I think is maybe similar. Maybe your answer is the same. He says, "Is there a danger that international, I presume meaning human rights law, maybe international humanitarian law, can be used in pursuit of?" Because he just put IHRL, can be used in pursuit of conflict-related objectives.
All right, okay.
So
again, I'm not exactly sure what is meant by conflict-related objectives, but I mean, if the question is whether these legal frameworks can facilitate that we engage with issues of accountability in conflict zones, then the answer is yes. And the answer is also that, well, at least for international humanitarian law, it was very much enacted to exactly ensure that that parties to an armed conflict respect certain basic rules, many of them relating to the protection of civilians and protection of prisoners of war and other people, other persons being in the power, in the detention power of another country. So that is the objective, exactly because the drafters of those conventions, they were aware that there is a huge risk that such persons in the detention within the detaining power could be subject to abuse. So it's very important to have that protection, and humanitarian law does a decent job, I think, in terms of setting out the details of that protection, but it doesn't give us all the details on how to pursue accountability when something goes wrong, which is why we saw the establishment of international criminal law, really, which is sort of a framework that facilitates accountability for the most serious violations of humanitarian law. And in terms of human rights, I mean, this is a long debate, and it goes a long time back. But if we are to just sort of describe how the situation is right now, then it is clear that human rights law does apply whenever someone is seen to be within the jurisdiction of state parties. So someone being held in detention, for example, would seem to be within the jurisdiction of the detaining power, and hence human rights law would, as the clear starting point, apply to that. And again, my view is that that is certainly a positive thing, because, well, first of all, it sets some limits on how you can treat the people you detain, but it also facilitates that that different forms of accountability and remedies can be pursued whenever those rules are not fully respected.
I don't want to put words in Martin or anyone's mouth, because it's a bit of a difficult means of having a conversation when one person's typing and another person's interpreting. But knowing a little bit about Northern Ireland, I mean, maybe the issue that's being raised is the sense of how what you're talking about, how does it relate to sort of state actors versus non-state actors? So in the Northern Ireland context, you might have some people saying, oh, well, if you pursue this type of an approach, you're generally aiming at state actors, which is a way of following a certain perspective of the conflict, if you know what I mean. So maybe that's what's a little bit behind some of those comments, and forgive me if I got that wrong for those who are listening, but maybe more broadly, how does what you're talking about relate to state and non-state actors, or is that not something you really focus on?
It is indeed something that I focused on in my own research, and in the submissions we did to the Commons Defence Committee. We've raised it as one of our key arguments, really, that it is hugely problematic from a rule of law perspective to introduce legislation that covers only certain categories of people. So in this case, the military, really, and so I would sort of fully agree with the sentiments behind the question, if I understand them correctly, that this is quite problematic to introduce the kind of legal protection for competence only of members of the armed forces only, and I can certainly see how that could be perceived in Northern Ireland as being very problematic from the point of view that I think you have to in your question. So I would totally agree.
Yeah, and Martin added there while you were talking, how does this apply to non-state actors who maybe not signed up to any international laws or other types of bodies?
The bill, as it is currently formulated, applies only to state actors. It applies only to members of the armed forces who served overseas. So that's important. If you speak more broadly about the legal frameworks, then international humanitarian law applies equally to state actors and non-state actors.
Yeah.
So an armed group that's a non-state actor would be bound by the rules of international humanitarian law, even if it hasn't consented to international humanitarian law, because that's sort of how international law more generally operates. That it is the state that consents to it, and then whatever it consents to can bind, different actors within its country. So there's nothing really, special about humanitarian law in that sense. But of course, it's important to note that the legal frameworks also apply to non-state actors.
There's quite a specific Northern Ireland question here from Mel McConville, who's one of our former MSc Peace and Conflict students, and I'm not sure it might be too specific for your research, Thomas, but he says if applied to the Northern Ireland context, and you've already explained this is outside of that, but if it was applied to the Northern Ireland context, would it have what ramifications might this have on the definition of who is a victim of the conflict?
It's interesting, of course. And it goes to many of those deeper questions in the Northern Ireland context. I'm not sure if the bill as such would have any. I haven't seen any arguments about that. They might be out there, but whether it would have any direct impact on who's understood to be a victim. But if you do read sort of the statement that was given by the Secretary of State for Northern Ireland, you see, I think I included one presentation, but sort of the picture that comes out of it is that they're saying, we committed to the rule of law, but let's forget about accountability. Anyways, it's such a long time ago, so let's focus on what they call information sharing. So in that sense, it would certainly limit access to justice for victims in a Northern Ireland context if as planned, similar measures are being introduced in Northern Ireland. So that's worth keeping in mind, surely.
So you're making reference here to the statement on the 28th of March by the Secretary of State, where the statement is really introduced from the perspective of having concerns about former British soldiers in Northern Ireland and essentially talking some cases might be closed.
So here's the statement that was given on the same day that the bill was introduced in the House of Commons, and you see that it's sort of emphasized here. It says it's the government's view that to best meet the needs of all victims and of wider society, we need to shift the focus of our approach to the past. While there must always be a route to justice, experience suggests that the likelihood of justice in most cases may now be small and continues to decrease as time passes. Our view is that we should now therefore center our attention on providing as much information as possible to families about what happened to their loved ones while this is still possible. So sort of, urging move our attention from issues of accountability to issues of getting access to information really seems to be the key message coming out of this. That's how I understand it, anyways.
Okay, so I think I'm going to start to wrap up here. I don't know if there's anything else you wanted to add, Thomas.
I just want to say thank you, of course, to everyone for joining in, and thanks to those who had very interesting and good questions to ask. I think there is a lot of questions that ought to be raised around these issues. I personally think it's very important that we engage this topic and keep monitoring what's going on and ask the tough questions that need to be asked. So thank you, everyone. Yeah.
Well, thanks very much, Thomas. There is a comment which Brian Doherty has put up onto the chat, and so I mean others can have a look at that. But Brian's really, I suppose, asking the questions at which maybe I should just read it. Maybe that's the easiest, and then others can react to it. I don't expect you necessarily, Thomas, to have to react to it, but we shouldn't underestimate the impact of one-sided narrative or pursuit policy has on good relations in Northern Ireland. Experience from the Historical Inquiries team to the Historical Investigations Unit has provided a perception of who shouts loudest, chronology and hierarchy of victims, particularly as many serving and ex-military still make up mainly the Protestant Unionist Loyalist community in the province. This is compounded by the lack of an effective voice for the sector. At what point do we draw a line under this? Which I guess, I mean, you don't need to necessarily address the detail of that, but I guess that's a core question at the heart of your research in some senses, and you're critiquing the attempts to maybe try and draw some lines. I'm not sure if you want to make a final comment, and then we can wrap it up.
Interesting, of course, and I suppose there's a reason why these investigations in the UK are always being referred to as historical investigations or historical teams. This is something of the past. This is something that, I mean, if you buy into that narrative, something you better just forget about accountability. At least it's no longer relevant. And of course, there are there are issues that can make it quite difficult to investigate and prosecute crimes that happened many years ago. I mean, forensics evidence and all of that, you name it, right? So there's surely some practical concerns. So from a moral point of view, I don't think, in my own take on it is that, I mean, the state's responsibilities do not disappear over time, that the state is and should remain responsible even after years have passed for very serious violations of international human rights law and humanitarian law. And in a sense, this is the notion that international criminal law, at least, is built around, that we don't accept time limits for these kind of crimes. They're so serious that they should be investigated and prosecuted, and if guilty, punished. Also even in situations where many years may have passed since they were committed. Yeah.
And you're quite clear also in your research that it feels that the UK is now also deviating from the European standard and approach on much of this, or trying to deviate.
Yeah, right. It looks like that. I mean, the requirements to investigate and prosecute under the European Convention, these the most serious violations, again, they do not just vanish after a couple of years, right? So it's something new, surely the UK is trying to do, and the effect, of course, also looking ahead, that there's a reason also why this litigation coming out of conflict zones quite often only happens a long time after the violations happened, because typically it's very difficult to pursue litigation and get access to lawyers and all of that while the conflict is still ongoing, right? So that's one very important practical argument, I think, why that there can be very good reasons that we don't see this litigation coming until maybe some years have passed since the violation took place. So that's important to keep in mind from sort of an access to justice perspective, I would say.
Well, thanks very much, Thomas. I won't ask you any more questions, and even though this is a very different platform and it's not face to face, I know it's pretty tough having to sit there for nearly 45 minutes getting questions at you and having to think on your feet. So I really appreciate that, and I found it really
enjoyed it. I really enjoyed it, Brandon. Yeah.
I found it really interesting, and to me, feels a bit like, having one's own personal human rights lawyer at the other end of the line and being able to ask them whatever complicated, difficult question you would like to ask them. So I really appreciate that. I think it was a fantastic addition to our series. I am going to ask Kate Turner from Healing Through Remembering just to make some final comments. I'll also put a couple of comments up in the chat box for those who are listening, any suggestions we might have for the future advertising the next seminar. So Kate, if you're there, do you want to pop in?
Thanks very much, Thomas. This is very different to what we discussed when we first approached you for this series. So thank you for taking on board doing things in such a different way. Thanks to Brandon for chairing it, and thanks to all the participants, especially those of you who've had to come in a couple of times in order to get the sound. But it's great to be able to have some kind of debate. Our next in the series will be on Wednesday, the 24th of June at the earlier time of 2 o'clock. The speakers are Claire Hackett, who was one of the participants asking questions today. She's from Falls Community Council and also Healing Through Remembering. And with her is Dr. Catherine O'Rourke from the University of Ulster and the Transitional Justice Institute. They're going to be reflecting on the exclusion of women and gender from the dominant approaches to dealing with the past. They're going to look at some specific interventions, possible strategies and approaches. So I hope those of you that are interested can join us for that one. Thanks very much, everybody.
Thank you, Kate. Thank you, everybody. And we hope to see you again. Thanks for making the time. And thanks again, Thomas, a really great, deeply informative seminar. And hopefully we see you at the next seminar. So thanks, everybody. Cheers.